Hello. This is the last session of the day, and I'm John Papahronis, and this is Alison Patel, and we're going to be talking about retirement plan corrections. And Alison and I are a little bit embarrassed, but our seminar organizers have had to bribe you all to stay to this point, to the end of our presentation. I don't know what that says about our session, but we do have the drawing for the iPad Mini at the end of this session. And you do have to be present to win. So we're a little embarrassed about that, but that's okay. We're going to talk about retirement plan corrections. And to start off, I'm going to talk first about the IRS's program for correcting retirement plan problems. And we know from our practice, and you all know, I won't ask for a show of hands or anything, but mistakes happen in the course of operating a retirement plan and administering the retirement plan. There's all sorts of administrative problems that can occur. The rules are really complicated in retirement plan administration. There's all sorts of amendments that have to be adopted from time to time. So problems happen. And it's very common that the problems happen. And if they're left uncorrected, those problems that occur can lead to problems with the IRS, potentially disqualification of the plan. And so they're not the type of thing that you can just ignore and hope that goes away or wears away with time. The IRS, several years ago, recognized that this is something that needs some guidance. So what they did is they started a program, or they issued guidance on a program. They call it the Employee Plans Resolution System, Compliance Resolution System. And what they did is they tried to put a structure in place where they could give guidance to employers on how to correct plans that occur with respect to their plans, the retirement plans. And they recognized it was in everybody's best interest, including theirs, the IRS, for employers to try to address the situations that come up and get them corrected. And so they put into place these rules, a whole program actually, to help people do that. Recently, the program has been updated about every 2 years, and the IRS has issued a new revenue procedure, 2013-12, which is the latest version of it. And there's been some modifications to the program, and I'll talk about those in a little bit. But I would point out, if you want to, in your materials, you might want to circle the revenue procedure as something that if you do have a problem in your plan, it is something that is it's fairly readable for an IRS publication, and it does give you different ways to figure out how to correct your problems. I'm going to skip the next 2 slides. These next 2 slides are the latest changes to the program. I kind of want to talk about what the program is, and then we'll go back and pick this up. So let's start on this. The next slide is options available. Basically, the EPCRS program is in 3 parts. The first part is what we think is the best part. It's the self-correction program. And these are problems with your retirement plan that can be corrected without filing with the IRS. And we'll talk about what the criteria are for qualifying for self-corrections. The second part is the next level up, and it's a voluntary compliance where you actually file with the IRS and propose a solution and get an IRS approval of your proposed solution. And at the end of that process, you get a compliance statement from the IRS approving that solution. Not as good as the first step because there's a filing fee, there's a process involved, there's expenses. So it's an option. It's not as desirable as the first option, obviously. And then the last part is the audit cap, and that is the resolution of a problem when the IRS comes in on an audit and there's a problem identified, and it's the resolution of that problem. I'm not going to talk about that here today. That's not, obviously, that's nothing that we ever want to get to. Hopefully, we find the problems before it ever gets to an audit, and so we're not going to talk about it today. Okay, taking the first step, self-correction. The self-correction program is for the correction of any problem there's one alternative is if the problem is insignificant and it's an operational failure, you can correct it at any time. So when we say insignificant, what the IRS is looking at is the amount of the dollar amount of the error, how many people it applied to, how big the plan is, things like that. And so if it's a relatively minor error, or if it doesn't occur, if it's not plan-wide, if you haven't made an error with respect to every participant in the plan, I would say that's going to be insignificant. There are different factors that you would look at to determine whether it's insignificant. Operational errors. So what is an operational error? An operational error is not a plan document error. So if you've missed a plan amendment or something has gone wrong with your plan in that manner, that's not an operational error. An operational error is really when the plan has not been operated in accordance with its terms. So if you fail to make make required minimum distributions when necessary, that's an operational error. Okay, insignificant errors, you can correct them at any time. If it's a significant error, you can still correct them under the self-correction procedure, but only if you do so within a window period, and the window period is within 2 years after the year in which the error occurred. So you can see that when a problem comes up or you identify a problem, the first step of your analysis has got to be, can I qualify for the self-correction procedure? And then you look at these different factors. Is it significant? Is it not significant? Is it within the time period? Is it not within the time period? As I said earlier, the big advantage of the self-correction procedure is there's no filing procedure with the IRS. There's no IRS approval. You basically fix the problem, and then what we highly recommend, and this goes for everything I'm going to discuss in this compliance section of the program, is that you document what you do, what the problem was, what your correction was, and that way you've got a memo in your file so that you remember what you did back when someone asked you about it later on. That might be the IRS that asked you about it, and many times I found that the CPA auditors of the plan that come in and audit the plan many times maybe they'll pick up on the error on themselves when they do their sampling, and they'll find the error and they'll ask you what you did about it. It's really nice if you've got a memo in your file that shows that you were on the ball and you caught the error and what you did and how you did it. There are also some additional requirements as to for qualifying for self-correction. You've got to have established plan procedures and a determination letter. Obviously, you can't use self-correction if it's really egregious, and there's no definition for what egregious is. But, it's kind of one of those things, you know it when you see it. But self-correction is not for egregious failures. Okay, the next step up is voluntary corrections. And these are when you actually propose a solution, you file it with the IRS, and there are some specific forms for doing that, and you pay a fee in connection with that application. You can't wait. You cannot use this procedure if the IRS has already started an audit. So it's too late at that point. Then you got to resolve it under audit cap. There are certain plan problems that can only be resolved using the VCP, voluntary compliance. And this slide summarizes those. If it's a government eligibility failure, if it's a significant operational failure outside the 2-year window that I talked about earlier, you have to do a VCP. If you fail to do a required minimum distribution, that can only be resolved with a VCP. Unfortunately, there's a couple of other categories of errors, and this is very frustrating. Plan loan errors and failure to obtain spousal consent on certain distributions. They can only be resolved with a VCP filing, which is very unfortunate because plan loan errors are pretty easy. They occur pretty frequently, and it's unfortunate that it can't be done on a cheaper basis. These are the fees that are applicable to voluntary compliance filings, and you can see it's based on the number of participants in the plan, and it can range from $750 for very small groups to $25,000 for very large groups. This is not a fee that can be paid out of the plan assets. So this is something to take into consideration. Some of these are most of the time I found that it doesn't cost that much relatively to the plan assets. There are also a special fee that applies to the correction of non-amending, the failure to amend the plan timely for required amendments, which is also another area that can only be corrected with a voluntary compliance filing. Okay, now I told you I was going to cover the current, the most recent changes. So I want to flip back. I'm sorry about this. To the slide about the changes in the EPCRS revenue procedure. As I said, recently the IRS updated their procedures, and they tinkered with it a little bit, and so they added some things that we didn't have before. Now you can use VCP for problems with the 403B annuity, and if you're a public school out there, you know what those are about. Those are a special type of retirement plan for educational and some other governmental entities and nonprofit. There are also some limited correction procedures that apply to another type of retirement plan called 457B plans. There are new forms that, this is mostly procedural, there are new forms to be used when you do file a VCP. One of the things that's, again, if you're an employer that has a 403B annuity, one of the things that has limited, kind of a limited window that you can take advantage of is that if you have a 403B plan, but it doesn't have a document, you can correct that under the VCP, but you have until December 31 of this year to do that. So we've found that occasionally occurs. We've seen that occasionally, or they can't find the plan document, and IRS has indicated that they're, like some other things that they've mentioned, this is something that they're going to start looking at a little bit more closely, governmental entities, and so that's something that is coming up. Okay, now I'm going to switch back. We're going to look at some examples of plan corrections. I'm sorry, I'm taking you back to where I left off the last time. Okay, I'm just going to give you a flavor for some of the types of problems that we see and how you correct them under the IRS's program. And let me say that if you look at the IRS's revenue procedure, it provides pretty detailed guidance on a lot of very common problems that occur. They don't address everything, though, and sometimes we find that there are situations that come up and you have to apply the principles of the revenue procedure to correct the problem, but there's not necessarily something that you can point to in the revenue procedure that specifically addresses that situation. But these situations that we're going to talk about here are situations that are addressed specifically in the revenue procedure. The first example is something we see from time to time, is when an employer has a 401k plan or retirement plan, and for some administrative breakdown occurs, and they fail to get somebody into the plan when they're eligible, and maybe that goes on for quite some time, up to more than a year sometimes. In this case, Bill was excluded from the 401k plan, and you can see his compensation was a certain amount, $40,000. The ADP, the average percentage for non-highly compensated employees in the plan, was 1.5%, and the plan provided a matching contribution. In that situation, the solution is the employer has to put in a contribution, and it's referred to as QNEC in the slide. A QNEC just means an employer contribution that's 100% vested. So basically, the employer is putting in a contribution to substitute for 50% of the average contribution amount that was made by employees in the plan. And so the employer puts in that 50%, in this case 50% times $40,000 times 1.5%, and then the employer would also have to put in an amount for the matching contribution that Bill didn't get. But in that case, the employer doesn't put just 50% of the match that he would have gotten. The employer puts in 100% of the match that Bill would have gotten based on the 401k deferral that we're assuming. Going back to the employer contribution on the 401k amount, the reason it's 50% is the IRS is saying, okay, we understand that the employer is correcting this situation. We don't want to make it a windfall for the employee, because the employee didn't have any 401k deferrals taken out of his salary, so he got the taxable compensation, and now the employer is going to put in 50% of what the 401k would have been, and that's pretty good for the employee. But if we required the employer to put in 100%, then the employee would have gotten basically double. So that would be too much of a penalty for the employer. Also, on both the matching and the employer contribution for the 401k, the employer has to calculate earnings on that amount, and those earnings have to go into the plan to make the correction. Okay, a second example is in the situation where the plan has permitted a distribution or made an overpayment. In this case, they've distributed too much to Bill, an amount that exceeded what his vested amount was in the plan. And so the employer has discovered this. Okay, what do we do in that situation? Bill has gotten too much money as a result of his distribution. Okay, first thing, there's really two parts to this. First, the employer can request that Bill send the money back to the plan so that it goes back in the plan. And if Bill did that, he would have to return it with earnings. It would go into the plan's forfeiture account, and everything would be fixed. Okay, most likely Bill is not going to return the money. I mean, he's gone. He's terminated employment. He gets a letter and he says, "I'm not giving it back. Come and get me." If he doesn't repay, then the employer has to put the money back in the plan, even though it's going to go in the forfeiture account. And the employer would send a letter to Bill saying, "Bill, that amount was not your money. It's not an eligible rollover distribution. So if you rolled it over to an IRA, that's not an eligible rollover distribution." What Bill does from there is his own business. And at that point, the employer's done all they can do to correct the situation. This sometimes happens when, and to be honest with you, a lot of times employers aren't running this part of the plan, these distributions and things like that. Sometimes it's the third-party administrator that commits the error, and sometimes it's the third-party administrator's fault for that. And so it could be instead of the employer putting in the money, The employer may go to the third-party administrator and say, we expect you to fix this, and so the third-party administrator may have to put the money back in. So you just have to look at what the situation is. It could be that it's someone else's fault, and so someone else needs to be responsible. Okay, our third example is when there's been a failure to make required minimum distributions from the plan. As many of you know, one of the provisions in your plan, and this comes straight out of the Internal Revenue Code, is that once an employee reaches age 70 and a half, and after he terminates employment, he has to start taking distributions from the plan. And those distributions have to be made over his lifetime. One additional part to that is if a person owns 5% or more of the stock of the company, he doesn't even have to terminate employment. If he reaches 70 and a half, you have to start distributions. And that's something it's pretty easy to slip up on, and I've seen that. If they don't start those distributions when they're supposed to, number one, you haven't followed the terms of your plan. So you have a plan qualification issue. Number two, the individual who hasn't received his minimum distributions is subject to a 50% excise tax on the amount that he should have gotten. It's a really draconian penalty on him. It may not be his fault. It may be whoever is administering the plan's fault for not making the distribution. What I've seen very often is that employers many times think that the third-party administrator is going to handle all that stuff, all the distributions, and many times when I look at the contracts that employers have with their third-party administrators, it doesn't even address this task. And so the third-party administrator doesn't have it on their list of what they're going to do for the plan. Third-party administrator is saying, okay, employer, you're responsible for that. And then the employer thinks that the third-party administrator is going to handle it. Sometimes this falls through the cracks. So if this happens, it can be a very significant problem for both the participant, because it's going to be subject to an excise tax, 50% of what should have been distributed, and it can also cause a problem to the plan because the plan hasn't followed its terms. Okay, there's two possible ways to correct this. One, the plan can just, the individual who should have received the distribution, he can catch up on what he should have received, and then he can file his tax return and request a waiver of the penalty from the IRS, that 50% penalty. I've helped clients with this when it's just been one person. The IRS generally approves those requests, but it's a little bit traumatic for the employee that's requesting that, because usually there's significant money involved, and so it's not quite the preferred approach, especially because it really doesn't resolve the problem on behalf of the plan. The plan didn't follow its terms. So the second approach is it's a little bit more involved, and that is actually filing a voluntary compliance filing with the IRS. That is especially a good solution where the employer hasn't done it for several people, and those other people are, it's the employer, maybe the employer or the third-party administrator's fault. The employer can file a VCP, voluntary compliance filing, with the IRS and request that the IRS waive the penalty on behalf of all those people that it affected, and approve that the plan is not in violation itself. And so if it does that, and it's a relatively small fee, it's like $500, which is in the great scheme of things not that much. In that way, the plan can take care of the participant and also fix the plan, and it will not. It basically handles a problem on behalf of the individual, and so it's really the best solution for a relatively small amount. Okay, Alison's going to talk about some of the other aspects of this involving the Department of Labor when these situations occur.
Thank you, John. Is the volume okay for everybody?
Yeah!
Thank you. I do have some good news. We are officially running a full 10 seconds ahead of schedule for those of you waiting on the iPad mini. You're going to be out of here in no time. So some bad news is that for those of you that are waiting on the iPad mini, I'm running the risk with all of you right now, but I'm sure that a few of you are going to feel that way when I state what it is that we're going to talk about next, which is the Department of Labor's voluntary correction program as opposed to the IRS. And of course, for those of you that deal with the DOL, they're mostly concerned with ERISA. And so what we're going to be going through today are things that are helpful for those that have plans that are subject to ERISA. So if you don't, my apologies. I will make this fast. We're really going to go over two DOL programs. There is the Voluntary Fiduciary Correction Program, which we're going to start with first. And this really is designed to allow employers and other parties in interest to correct fiduciary violations under ERISA that have occurred in order to avoid additional civil penalties. So basically, ERISA, as you all know, puts employers, sponsors of plans, trustees of plans, service providers to plans, any of those people that are considered fiduciaries. ERISA imposes guidelines and responsibilities on those individuals and companies to perform in a way that's really only in the best interest of the participants in that plan. So as Jim was saying in the last session, you can't steal money and you need not to lie to them. That's really what the major goal is. But there's a lot of obvious intricacies that go into whether or not you are in fact following your fiduciary duties. And so when you get in a situation where maybe you've not abided by your duties as a fiduciary, the DOL decided that it'd be a good idea to provide a program for people to voluntarily notify the DOL or the subset of DOL, which is the Employee Benefit Security Administration, that they had in fact made an error. And that allows you to avoid some of the civil penalties. So in order to be eligible for this, first, you have to be a plan fiduciary and you have to be liable for some sort of violation under ERISA, and you cannot currently be under investigation from the DOL or EPSA. So that's really the only level of eligibility, is that you've created a violation that's correctable, you're a fiduciary, you're not under investigation. A lot of people, when they have an error, say, okay, well, we've made an error, but and we're going to correct that error, but why in the world would we notify the DOL that we have made an error in our plan? That seems like we're just drawing attention to ourselves. And the real reason that people take advantage of this is because of the no action letter that you would receive to the extent that you correctly correct your violation and send it in and get it approved. They'll issue a no action letter with respect to that particular transaction that you're trying to correct. And they won't conduct a civil investigation, and they won't assess the civil penalties that would otherwise be assessed against you if it were to be found on audit or some other way was identified. The penalties would be much more severe to the extent that prohibited transaction were to be discovered in a way that wasn't your notification to them. So there is that benefit. Now, it doesn't keep you safe from everything. If this is really an egregious violation that potentially is going to subject you to criminal penalties, this is not going to get you out from under the potential that the DOL may perform a criminal investigation on the transaction. So if it's a really terrible situation where it was the fiduciaries knowingly were doing something that clearly was not to the benefit of plan participants or beneficiaries, then that may be a different situation that needs to be handled outside of the program. It also doesn't keep them from notifying other governmental entities about the failure, so especially the IRS. In some cases, they're actually required to tell the IRS that this has happened. And for those of you who aren't subject to ERISA, you do have plans that are subject to the Internal Revenue Code. Well, the Internal Revenue Code has very similar provisions as it relates to what they call prohibited transactions between the plan and a party in interest, or what the IRS calls a disqualified person. So there are similar failures that the IRS will look at, and they will assess an excise tax for those transactions. So you're not completely out of the woods if you're not subject to ERISA. You are just not eligible to correct under the fiduciary correction program. So you may still get contacted by the IRS, and a lot of times at the time that you're correcting under the fiduciary correction program, you would also be not correcting under some sort of voluntary program, but you would be filing a 5330 with the IRS, which is basically just a form of you reporting certain prohibited transactions and paying an excise tax up front, as opposed to having them find it and paying a much higher excise tax in the future. So there are some exemptions to the IRS excise tax, and I will go over those later. Okay, so how do you apply? So if you've got a violation, let's say that you have there's been an improper sale of assets between the plan and a party in interest, and you're correcting it. So how do you go about fixing this? Well, first you have to identify that specific transaction that happened is one of those that the DOL allows to be fixed through the voluntary correction program. Then you have to follow the process for correcting the specific violations. I haven't included those in here because it's really the DOL. If you go to their website or if you just do a Google search that says Voluntary Fiduciary Correction Program, it will take you immediately to several links on the DOL's website, and there is just a ton of information on doing this because their goal is for people to voluntarily come forward. So if you have a violation, either contact an attorney that your plan works with, or just if you want to do some initial research, the DOL's website is a fantastic place to go, and it will tell you kind of step by step. The program walks you through what you need to do in the event of specific failures. Then you're obviously going to have to correct the failure. You're going to have to calculate and restore any losses that were suffered by the plan, or if as a result of the failure, instead of the plan having losses, if the party in interest that was incorrectly using the assets gained some sort of a profit, if that amount's greater, then we're going to recoup to the plan the amount of the profits that the employer or the provider or whomever received. And then once you've done that correction, you're going to file with your regional EPSA office the documentation showing evidence that you've taken the corrective action. And that's really what it is. You're just sending in notification and a summary of what's happened and what you've done to correct it, and you're sending it off to them for their approval so that they will send you the no action letter. So there is an unlimited number of ways that you can make a fiduciary mistake when you're a fiduciary to a plan. And so in understanding that, the DOL has basically said, well, what types of failures do we think that can easily be corrected by the employers or sponsors themselves, as opposed to needing a lot of assistance from the DOL or EPSA? And so they've identified 19 categories of transactions that they're willing to allow you to correct through this program. I've not listed them all here. Again, if you type this in, the DOL has a full list of the 19. I didn't know that it was necessary to go through them all, but just to give you kind of a flavor of what we're talking about as to when this might apply to you, I've picked some that are more frequently incurred than others. First one, and I see this one the most by far, delinquent participant contributions and participant loan repayments to pension plans. This happens all the time. People don't really realize that ERISA requires amounts to be segregated and put into the plan very quickly after they've been pulled from a salary deferral or something of that nature. So you've got to stay really on top of, if people are making salary deferrals into the plan, those amounts need to be very quickly moved over to the plan's assets. A lot of employers will just, especially smaller employers, will miss payrolls at times or just get behind. They have a person who's doing a lot of things besides just the transmission, and so there are more failures that happen and it's not realized until later on. So that's probably that is considered a violation of ERISA and of your fiduciary obligations. Participant loans failing to comply with plan provisions for the amount and duration or level amortization happens quite a bit. Defaulted participant loans. Payment of duplicate, excessive, or unnecessary compensation. So in addition to you not being able, as a fiduciary, to do something that's for the benefit of a party in interest versus the plan's participants, part of that is they're saying there needs to be a duty of prudence. So if you're hiring service providers or others to perform services for the plan, then it's your responsibility as a fiduciary to make sure that the compensation that they're receiving is reasonable. So that's certainly something. Everybody hears about fees these days and everything else. That's one of the violations that is discussed. Improper payment of expenses by plan. There are certain plan expenses that the plan cannot pay. A lot of employers pay many of the costs of a plan through the plan expenses, and that's fine for the most part, but there are certain expenses referred to as settlor expenses that are not supposed to be paid by the plan. And so to the extent the plan is paid for those, that's a violation that needs to be cured. Purchase of assets by plans from parties in interest, and sale of assets by plans to parties in interest. These are all things, shouldn't be having transactions between the two. Acceptable corrections. Really, at the end of the day, what the DOL wants is they just want you to restore the plan to whatever position it would have been in had this not happened. So had the violation not occurred, where would you be? We want it to be back to that place or better. So in some situations, you're going to need to do valuations of assets. If we're dealing with real property or securities or something to that effect, you may need to understand what the value even is in order to correct it. So in some cases, you may need an appraisal in order to correct. It'll just depend on the violation you're talking about. The second one you're definitely going to have to do, you have to restore the plan, the principal amount involved. So in a delinquent contribution, the principal amount is whatever the deferral contributions were that you did not put into the plan. That's the principal amount. Plus the greater of the lost earnings or the restoration of profits. And you're measuring that from a period between the date of the loss, which is the date that it should have gone in, or that the transaction occurred, and the recovery date when you fix it. So pay the expenses of correcting. A lot of times what will happen is you will get an attorney involved or you'll get somebody else involved to help you fix the error and to do it under the correction program. And then you pay those expenses out of your plan assets because you're used to paying attorney's fees out of plan assets for the ongoing administration of your plan. You cannot do that when you're correcting a violation. So if the DOL said if you're correcting a fiduciary violation, well then you, the fiduciary, needs to take care of the costs associated with doing that. And then in some instances you have former employees that you need to make supplemental distributions to, and so you'll need to provide proof of the payments to those individuals who are no longer with the plan. Okay, the excise tax exemption. This is, when you're correcting under the fiduciary correction program, you're thinking, okay, well, I'm getting this relief from the DOL, but they're going to notify the IRS that I've had a prohibited transaction, and the IRS, if I don't correct it, the IRS is going to assess a 15% excise tax. Well, if they find it before I correct it, it's going to be much higher than that. But 15% to the extent you're correcting prohibited transactions is what you can count on. You can get an exemption from that through the fiduciary correction program for 6 particular transactions. There are definitely requirements that have to be met in order to qualify for that. You're going to have to notify people who have been affected. That's really the biggest hurdle that a lot of people have, is getting through the notification, because if you're a large employer, you're going to have a ton of people to correct. So there are requirements that have to be met, but just keep in mind, if you have a violation, to ask whoever you're working with, do we qualify for an exemption for the excise tax? Because if so, we want to pursue that. The ones that in some instances are listed here: the failure to timely remit, loans at fair market interest rate with parties in interest. The key there is that they're at the fair market interest rate, so that the DOL is saying and the IRS is saying, yes, you had a prohibited transaction, you shouldn't have been dealing with one another, but at least at a minimum it appears to be somewhat of an arm's length, so the plan wasn't being unfairly negotiated with. Purchases and sales of assets between plans and parties in interest at fair market value, again, fair market value being the key there. Sales of real property to plans by employers and the leaseback of that property at fair market value or fair market rental value. Prohibited transaction violations involved in the purchase of an asset when the asset has been deemed illiquid. And then again, we've already talked about this, the use of plan assets to pay expenses to a service provider that are settlor expenses, provided that your plan doesn't prohibit you from using plan assets for that reason. The only violation really is the ERISA violation. Otherwise, you have a plan violation as well. So how do you use the fiduciary correction program? Here is just one example, and again, I'm just going to stick with the most common because this is more likely to happen to you all probably than others. So a late deposit of participant contributions. So the general rule with participant contributions is that you have to deposit the contributions in the plan as soon as they can reasonably be segregated from your general assets. And then it provides this end date, which is that it has to be no later than 15 business days. The 15th business day of the month after the month in which the amounts were withheld. That second portion of that, do not rely on the second portion of that. That is not what the DOL really views anymore as being reasonable for most plans, especially for large plans. For large plans, they expect your turnaround to be incredibly quick. If you're a large employer, they're expecting you to have very sophisticated software that's going to allow you to very quickly turn over those deferrals. So just keep in mind that really the question is, was it reasonable? It wasn't a reasonable amount of time between the time that you received the contribution and the time that you remitted it to the plan. So there is a small plan safe harbor. So if you have fewer than 100 participants in your plan, then the DOL has basically said that if you deposit it no later than the 7th business day following the date withheld, which as you can see is smaller than the maximum that they provided on the earlier page. If you're a small plan, fantastic. Then they're happy with that. So small plans at least know they don't have this gray area of what's reasonable for us. So that's good news for the small plans as far as some certainty to the situation. So in this example, we're going to take a large 401k plan. And the reasonable time for this particular large 401k plan to segregate deferrals is on the same day as they're withheld from employee paychecks. So for the pay period ending June 15th, elected deferrals totaling $250,000 were not deposited into the trust until June 30th. So basically, they're 15 days late. They could have deposited on the 15th of June. Instead, we're looking at June 30th. So how do you correct this? Well, basically, the correction method is just to deposit the late amounts into the plan. So go ahead and get those amounts in, and then we say lost earnings here. It really is the greater of lost earnings or restoration of profits. Typically, though, when you're dealing with a delinquent participant contribution, the employer's not done that because they're using the assets for anything in particular. And you have to be able to identify, well, we took that money and we did this with it and it turned this much profit. That's not what's usually happening in a delinquent filer. It's just really very typically an inadvertent mistake or some very few people. It's not even always the entire group. It's just a few individuals who didn't get it pushed through. So more often than not, I've never seen one that wasn't a lost earnings situation. So you're really just going to put those amounts back into the plan as correction. The lost earnings amount is really, it's calculated between the lost date, and in this situation, the lost date would be June 15th because that's when it could have been segregated, and the recovery date. Now, the recovery date's when you actually restore the plan with the amounts. So in this situation, they've restored the plan on June 30th because they then deposited the amounts on June 30th. Well, here's the problem. And this is why you see and the final payment date. While you've corrected the fact that you didn't defer, you haven't corrected the lost earnings yet. So if you're delaying, you're also going to have to do the lost earnings plus interest. Now the good news is that the DOL has got a very nice online calculator where literally you just have to put in the principal amount, the lost date, the recovery date, and the final payment date. And it will calculate for you what you're dealing with in the way of lost earnings and interest. So it's honestly a very simple program to use, especially for corrections like this. So that's really the extent of correcting the plan. Now you also have to pay as the employer the fees and costs associated with doing the correction, but that really is the correction. However, if you don't qualify for the IRS excise tax exemption, if you're not going to notify, if you've done this within the last 3 years, you're not going to qualify for that exemption. And so you also, at the same time, should go ahead and file your Form 5330 with the IRS. And basically, it's, you have to have a pretty large amount of contributions that haven't been input for a long period of time in order for that number to become very large. Because if you're 15 days late, that's not a lot of time to be paying interest on something. And that's really what the excise tax on these is based off, is how much the amount involved is really what's been the lost earnings, basically. So it's really not expensive, but you will want to file it with the IRS at the same time because they will notify the IRS. So that's really the fiduciary correction program. The second one for the DOL is the delinquent filer. So ERISA plans required to file the 5500s annually. And while we're really focusing on retirement plans today, we honestly see this violation a lot more with health and welfare plans that employers don't realize are required to file 5500s. So with most pension plans, a lot of people understand that this is a requirement, and so they're in the habit of doing it already. But with some health and welfare plans, we're seeing a lot of employers that are coming forward. Either they've been audited or someone's brought it to their attention that they needed to be doing 5500s, and so now they're saying, well, what do we do? We're in violation, and the fees for being in violation are pretty substantial. So the DOL came up with this delinquent filer voluntary compliance program. Basically, it's very simple. All you do is you fill out the 5500 for the years that you missed, and you check box D that basically says that this is under the delinquent filer, and you submit a statement that that's what you're doing with this report so that they understand why you're submitting an old 5500 and that they know that you're trying to get this favorable treatment for voluntarily correcting it. File this normally with your EFAS the way that you do all your current ones. And then the only really thing that you're doing in addition to just doing these late 5500s is you submit the payment and you file that information with the DFVCP. And you submit a copy of the 5500. Don't include all of your attachments. They don't want all that. They just want to know that you filed it. And the penalty check for the applicable penalty amount, which we'll talk about in a second. Notice that this is not available if you've already been notified by the DOL in writing that there's a failure to file, unless they tell you that they're going to give you some time. But you will also get notifications from the IRS. That won't stop you from filing with the DOL. So if you get an IRS notification requesting where's your 5500, don't think that that necessarily keeps you out of this opportunity. So what's the penalty amount? So for small plans, that's less than 100 participants at the beginning of the plan year, it's $10 a day. The nice thing about this program is that there's a cap on that, which means that it's $10 a day, but they're not going to let it exceed $750. If you have multiple years, they won't let it exceed $1,500 per plan. So if the same plan has a lot of years of failures, you're limited to a $1,500 penalty, which is nice. For large plans, 100 plus participants at the beginning of the year, again, it's $10 a day, and the cap's a little bit higher. It's $2,000 on a cap for a particular year, for a particular plan. If you have multiple years for one plan, cap at $4,000. That's the end of it. Unless that's all. Thanks so much for coming.
Thanks for coming today.